morning, good afternoon, doctors, and welcome to today's webinar. We'll get the webinar started. I know a number of doctors are beginning their login process, but it's just about noon here on Eastern Standard Time, so I thought it'd be best just to get the program started today. Welcome all to our webinar on risk management, reducing practice liability and operating costs. My name is Jazz Banga. I'm one of the senior consultants here with the Healthcare Leasing Division team at Cirrus Consulting Group. I'm joined today by Adrienne Twigg with Bent Ericksen. She is the HR and Employment Compliance Specialist, and there'll be two components of today's webinar, the first being on the leasing component of the business, how we can reduce our risk and liability, and some key items to take into consideration when negotiating a brand new lease, a renewal of a lease agreement, or when we're planning for transition. Adrienne will touch base on HR and employment compliance concerns, and she'll be essentially discussing what you don't know can hurt you when it comes to HR. With that being said, I'd like to begin this afternoon or morning's program, depending on where you are in the world. So let's get started. So a little bit of background on our firm, just to give you an all idea of who we are, what we do, and how we've been supporting the dental community for the many years that we've been in business. We were essentially founded by a group of dentists back in 1994. For the latter part of 25 years now, we have been advising and representing dentists when it comes to their office lease agreements, negotiating critical terms, ensuring that rental rates are fair and reasonable, and ensuring that the community is aware of the exact obligations and commitments that they're signing forward for the next 10 or 20 years when it comes to their office lease agreement. Over the course of our last 25 years, we've negotiated over 10,000 lease agreements, and this stretches all over North America, up to Canada as well as the United States, from Hawaii, Alaska, California. Really, in the last 25 years, we've ingrained ourselves with the landlord community and very familiar with the process of negotiating with the sophisticated landlords, some of the real estate investment trusts, as well as the smaller mom and pop landlords. On an annualized basis, we represent over 1,000 doctors, and how our group is structured is very unique. We do have an in-house legal counsel. They effectively provide all the amendments, red lines, all the legal provision and changes to the lease agreement. We also have an in-house leasing team that operates similar to a brokerage in the sense that they provide us with details on KPIs, average rental rates, current rental rate standings, as well as availabilities in a particular market. So when we get into the economic portion of the negotiation, it's critical that we understand what fair market value is based on market comparables. We also have our consulting division, which is what I'm a part of. I'm one of the senior consultants here at Cirrus, and our role as a consultant is to provide strategy and advice on how to negotiate a better deal, and really understanding each doctor's and unique clinic's issues and concerns and how to address them when it comes to the real estate standpoint. In addition to the work that we do on behalf of our clients, another component of our business is to provide educational programs via CE credits all across the country, whether that be a live seminar or a webinar like today's program. We're effectively advising doctors on how to strategize and structure their lease agreement to protect their long-term interests with their space. As you can imagine, as a dentist or a healthcare practitioner, the lease agreement is a fundamental document in operating your business. We also lecture at many of the major dental conventions, Greater New York, Pacific Dental, Yankee Dental. So if you ever see a team member there with the Cirrus badge, be sure to say hi, and if you have any questions regarding your lease agreement or potential real estate concern, they would be more than happy to address, or even so, just come by and say hi. Now, in terms of some of the work that we do with doctors, I did want to point out some critical facts regarding the business of dentistry. In our experience, we have noted that over 75% of dentists have signed lease agreements that make it very difficult for them to sell. I'll touch base in greater detail as we move through the webinar on the type of language that is often found in a common dental office lease agreement, as well as give you guidance on the best way to structure that going forward to ensure that the practice lease is transferable and that we can effectively sell the business. Many of the doctors that I speak with often have significant personal exposures in their lease agreements that affect their personal assets, their home, their car, their estate. So we'll also go into great detail on how to properly structure and minimizing your exposure and personal liability. Now, on the other side of the coin, what makes dentists such a unique tenant? First and foremost, dentists have one of the lowest default rates in commercial real estate. When we're talking about the average tenant, groups like a nail salon, a restaurant, even a law firm or insurance broker. So in these cases, default rates are much higher, and because the business of dentistry, it is a very costly business to enter into. On a per square footage basis, it is one of the most expensive businesses to enter into. So our significant investment ensures that we are long-term stable tenants. Typically, when we build out and retrofit the space to make it dental specific, we are heavily invested into that asset. Therefore, typically stay for a long time. Dentists also drive a lot of foot traffic. Many patients come on a daily basis to the practice, and they're driving traffic, whether it's to a retail center, a medical building, or just an independent property. Foot traffic is highly increased when we have a dental practitioner in the property. And then lastly, because we have such a high investment into the practice and actually investing into the property itself, we do, as a dental tenant, typically take on a long-term tenancy. Many times when we're dealing with a doctor that is looking to start up a practice, we often recommend starting a lease agreement with 20 years of term, a 10-year initial period with 2 5-year options. The more term that the landlord has for their tenants, the higher their valuation of their building is. They have long-term predictability of revenue via a locked-in tenant, therefore the property valuation goes up. Of course, we're going to go into greater detail as we move through the program, but I just wanted to point out and highlight the significant importance of being a dental tenant. So what is the purpose of this portion of today's webinar? First and foremost, we're going to discuss steps to opening a practice and negotiating a risk-free lease, how to mitigate our risk exposure, how to ensure that our financials are fair and reasonable, and generally understanding how to make a standard commercial real estate agreement more dental specific. The second component we'll discuss a very important component of our overhead costs. In addition to our base rental rates, as a tenant, we are often expected to pay our triple net costs. That being triple net leases, our base rents plus additionals, taxes, maintenance, and insurance. On the maintenance side, many doctors overpay in CAM, and we will discuss strategies to reducing our CAM costs. And when I use the term CAM or TMI or triple net, they're all referring to the additionals. TMI being taxes, maintenance, and insurance, and CAM being common area maintenance costs. As a commercial tenant, we are expected to pay both our base rent as well as the pass-throughs from the building. We'll also discuss how to improve personal guarantees in the lease. How can we reduce our personal risk associated with signing a lease agreement and eliminating that personal guarantee where we collateralize our personal assets under the lease agreement, or at the very least limiting those guarantees and providing some step downs and mechanisms whereby as time goes on, our risk exposures would be diminished as time goes on. I'll also like to include a very particular element that is unique to the business of dentistry, and that is how to add a death and disability protection into the lease agreement. I'll go into greater detail as we move forward in the program today, but a great item to add into a lease agreement to protect your family, your home, your car, your estate in the event of death or disability. And then lastly, but also one of the most important items in any lease agreement, given that the business of dentistry, we often sell the business where we transfer the lease agreement. So we do want to structure the lease agreement from the onset to minimize any landlord interference when we're looking to sign or transfer that lease agreement. So the first question I'd like to ask everyone is, what is a lease agreement? And many doctors believe, a lease agreement is a legal obligation and commitment towards a space governing the relationship between landlord and tenant. I often like to look at a lease agreement as a check. As a dental tenant, it is one of the most, if not the most, expensive check that you will write in your entire life. One of the elements and mindsets that we're trying to change here at Cirrus Consulting is to educate our doctors in understanding that we cannot look at the lease agreement as a single year document. We need to look at the lease agreement in its entirety for the initial 10 years plus the 2 5-year option. And in many cases, the lease agreement, that commitment, that financial obligation that we are committing for the next 10 years is the most expensive obligation that we have. So critical that we have the economics done correctly from the beginning, and we do need to understand that we are signing off and essentially authorizing ourselves to commit to the landlord for many years and paying rent for many years to that landlord. So in exchange for that rent, there are also other considerations that the landlord needs to provide for us as this well-established, long-term, stable tenant that we are as dentists. So why is the office lease so important? First and foremost, the significant investment in cost of building a practice. On a per square footage basis, entering into the business of dentistry is the most expensive industry to enter into. Considerable costs when we're looking to retrofit, outfit, and build out a space. In terms of cost for leasehold improvements, a very considerable cost when we're looking at all the plumbing that belongs into a dental practice as well as electrical. So very high cost in entering into the business of dentistry. Very difficult to move once we have built into the concrete floor of a property. And again, very time consuming to move. On average, I'm sure many of you that have gone through a build out of practice can appreciate the significant time it takes to build out a practice. At the bare minimum, it takes typically 6 months to build out a practice. But on average, we see somewhere between 9 months to 12 months from when we've secured a lease agreement to going through site design, plans, variances, getting building permits from the county, the city, to begin the process of retrofitting the space, and then formally going through the fitting and outfit of the space with our contractors. So very time consuming to move and build the practice. And in the event that we are moving the space, patient attrition is associated with that, where we often see with each 1 mile move or 3 kilometer move from the practice, we typically see a 10 to 20% reduction in patients in the form of attrition. So critical that if we are entertaining the idea of a relocation, that we do take that in mind, not only the time, but the attrition that may be caused with the move from one area and one community to the other. And then the leases, lastly, but most importantly, critical to the practice sale. Very often we need to get consent from the landlord, and the landlord has full rights to interfere with that transfer. So one of the things that I'd like all of you to take away from today's lecture is understanding what your assignment process looks like, how that process will unfold, and to ensure that we have minimal landlord interference when it does come time to sell the business. So what should the lease do for you? When we do have a properly structured lease agreement, it should provide you long-term stability and security. So in the form of long-term stability, we typically like to see deals that are 10 years plus 2 5-year options, minimal risk in terms of our long-term stability. We have a legal binding document that allows us to stay in the space for many years, and we have predictability that we will be retained and remain as a tenant in their property, in the landlord's property, for many years to come. The lease agreement also allows you to transfer or sell the business. It either enhances or restricts your ability to sell the practice. And we'll spend an extensive amount of time in today's lecture discussing that. We do also want to ensure that the lease agreement is properly set up with fair and affordable financial terms, that we are aware of the fair market values in the area, what comparable properties are selling at and are listing their properties on a per square footage basis. And we do want to be in line with the market, because with most lease agreements, they typically go up year over year. So it's critical that at the beginning of the lease agreement, the lease is structured at fair market value. And last but not least, we do want to ensure that we minimize our risk and exposures via the lease agreement, eliminating any personal guarantees, ensuring that we do not have to restore the space back to its original shell, that the landlord cannot redevelop the property or relocate us, which is a very costly expense that, unbeknownst to many doctors, because they were not aware of what the provisions of their lease were, they were hit by surprise, and it caused many issues going forward. And of course, we want to ensure we maximize your flexibility as a practitioner. So we work as a group with many of the practice appraisal companies like AFCO, Roycorp, Tier 3, and this pie chart is not an exact breakdown of exactly how an appraisal is, but it does highlight some of the different elements that do go into an appraisal. Number one, when we're getting a practice appraised, when we're looking to sell it and or acquire a practice that's pre-existing, we do take a look at the depreciated value of the leasehold improvements. What is the status of the equipment? Is it new? Is it digital? Are we paperless? Are we dealing with digital x-rays? So on and so forth. So even though we're taking on a significant investment at the beginning to acquire equipment, we do recuperate those investment costs when we do sell the business, as equipment does factor into the overall valuation. The second and most largest component of the valuation is the patient goodwill. And when I speak of patient goodwill, I'm not talking about how many patients we have. I'm talking about the value each patient brings to the practice on an annualized basis. And that provides a fundamental basis of what the practice is appraised at. And last but not least would be the lease itself, what the rental rates are. Is it assignable? Are the rights transferable? Are options, such as options to renew, right of first refusals, right to purchases, or even the death and disability clause, are those transferable to the new buyer when they're acquiring your business? The lease has 100% impact on the valuation of your business. If we're unable to transfer the lease agreement, we're what's in your lease agreement? Did you know that most dental tenants have signed a lease agreement with overly restrictive terms that may prevent them from selling their practice? Unfortunately, most dentists are forced to learn this the hard way, and in many cases, it jeopardizes the sale or the clinic, or devalues the total valuation of the business. So one of the elements I do like to highlight today in today's webinar is assignability. Ensure that we can transfer that lease. And I will reiterate this throughout the program, because in my experience, we often see issues arise with the landlord once the owner of the practice is looking to sell the business. So I'd like everyone to take a look at this particular slide in today's lecture and spend a quick moment to read this over. I know we are a little bit stretched for time because we do have another component of this webinar today. So I'll quickly go over it and identify some of the issues. And again, this is found in 75% of office leases and dental-specific lease agreements. So if the tenant should wish to sign or sublet the lease premises, it shall first have received consent from the landlord. Any request for such consent shall be in writing. Within 15 days after receipt by landlord of such request for consent, the landlord shall have the option to either terminate the lease or to revise the minimum rent to be paid during the remainder of the term to the greater of the then current market rent for the premises, or 15% greater than the current rent. Notwithstanding the landlord's consent to any assignment or subletting, the tenant shall not be released from his obligation under lease and shall remain liable for any failure of the tenant or its assigning or subtenants to observe each and every covenant of the lease. Now, what does all this legal jargon mean? Number one, the first issue that we identify is the option to either terminate this lease or to revise the minimum rent. With this particular assignment language in this lease agreement, and again, this is found in 75% of lease agreements, the landlord has the option immediately, when we request a transfer of the lease, to terminate the document. Very, very difficult for us to ever sell the business if the landlord is looking to terminate the lease, and it does hinder our ability to sell or transfer. The landlord also has the ability to revise the minimum rent to the then greater market rental rate, or 15% greater than market rent. Again, if we have a prospective buyer and we've agreed to an asset purchase agreement based on the current condition of the practice, the revenue, the goodwill, as well as the rental rates that are currently structured in the lease agreement, having a revised rental rate will certainly hinder the valuation of the practice, because the buyer will realize that over the course of 10 years, they're paying significantly over market. So this is not the ideal type of language to see. Typically, we want to ensure that the landlord cannot condition or delay And I encourage all of you to take a look at your assignment language and to understand what controls the landlord may have when it does come time to sell. The second issue with this particular provision is a notion of continuous liability. So in the end, when we decide to transfer and sell the business, we have joint and severable liability with the buyer. So even though we sold the business and have left the practice and no longer have ties, we do have a financial connection with the practice as we are guaranteeing the lease. So if, for example, the buyer who had acquired your business defaulted on the lease agreement, claimed bankruptcy, or, for example, the landlord was unable to recuperate rent rates or damages from them directly, then according to the provisions of this lease agreement, us as the seller would be jointly liable. Therefore, if the landlord needed to recuperate damages, they could come after us as well. Not ideal. We do want to absolve our liability after the transfer and sale of the business. Critical that we address that on the early onset of the negotiations, because it will have impact in the last portion of our agreement when we look to sell the business. So did you know that most commercial tenants, dentists included, have agreed to provide their landlords with unconditional personal guarantees, thus exposing their family and estate to unnecessary risk? So what is a personal guarantee? A personal guarantee is when we collateralize our personal assets, home, car, estate, and investments, as well as those of our beneficiaries under the lease agreement. So if, for example, we were in default of the lease agreement and the landlord could not recuperate damages from our PC, our S-Corp, or our LLC, when we provide a personal guarantee, the landlord can come after our personal assets. In most cases, when a starting doctor is beginning their practice, the landlords will require some form of a guarantee. What we look to do as time goes on and we become a well-established tenured doctor, we do look to eliminate that guarantee, eliminate it altogether, or phase it out gradually, or cap it to a set period of time. So again, in this provision, which is found in 90% of lease agreements, it does say that the guarantor, i.e. the signing dentist, the named tenant, will be unconditionally bound to the lease. Not only are they guaranteeing the lease for the initial term, but for any options. So when we express those options at 10 plus 25, we would still be guaranteeing the lease under the conditions currently in the lease agreement. And of course, in many cases, the landlord will outline and have a structure out of guarantor form where we are effectively signing off our personal assets under the lease. Again, critical that we address that when we're dealing with any negotiation and have a discussion about eliminating any personal ties, separating our personal assets from the practice assets. It's particularly important as we get into the latter stages of our career and are starting to begin to plan for our transition. Another critical provision that to minimize our risk and exposure in the lease agreement is a death and disability protection. If you're no longer able to work due to disability, who will pay off your debts and monthly rent obligations? If there's a mental incapacitation or we have a physical disability, and that's very common in the business of dentistry, where we see doctors start to have hand problems, whether that be tremors, carpal tunnel, arthritis, or even back problems. We do like to incorporate a mechanism into the lease agreement whereby we can effectively terminate the lease or have our estate transfer the lease with minimal to no penalty. Very difficult to pay off any practice debts or even pay off our rental rates when we are no longer able to practice in the space, whether that be by death or disability, and effectively our estate is obligated to pay our rental rate. So critical that we add that in a dental specific deal, because without a dentist practicing in the space, there is no one to drive revenue and production in the space. So there needs to be a mechanism to terminate or effectively cancel that lease agreement. It is an added insurance policy into the lease. It also is a value add when we're looking to get the practice appraised, because if this right is transferable to a buyer, it will provide them that protection as well when the buyer is acquiring your business. Great to have in a lease, and it does improve valuation. Again, There are a number of other traps. In the interest of time, I know we are running a little bit short on time for the leasing component of today's practice, but when we get involved in a review or negotiation, there are a number of metrics that we're looking to improve when we're dealing with dental deals. In addition to the items that I mentioned already, we do want to, from a risk and liability exposure standpoint, we do want to ensure that we do not have any demolition rights, where the landlord can provide us a notice in the interest of redeveloping or demolishing the property. Because of that significant investment, it does hinder our practice asset when we do have a demolition right. We also want to ensure that we do not have a relocation right, whereby the landlord can effectively relocate us to another space in the property. Very difficult for a dental tenant to pick up their practice and move it, even if it's a few units down the hall. There is a considerable amount of work in terms of leasehold improvements, and the time delay can cause significant patient attrition, which in many cases is not recuperable. We also want to ensure that during the surrender process, at the end of our lease, we are not obligated to restore the space back to our original shell. So again, when we do a lease review, these are the number of metrics that we're taking a look at to ensure that all aspects of your lease agreement are addressed and have language in them to make them dental specific. So guys, one thing I want all of you to take away from today's seminar, critical item is a tenant lease cycle. When we get involved in deals, we typically advise our clients when it is a renewing tenant to begin the process early. From a leverage standpoint, the earlier we get started, the more leverage we have in the negotiations. So as you can see here, we typically advise our clients to begin the process 24 months prior to expiration. And the closer and closer we get to our expiration date, our leverage significantly diminishes. Landlords understand that it's very difficult for us to move, very difficult for us to rebuild a practice, and essentially can pass us any deal when we're in that last 6 to 8 month window, and we have to effectively sign it because we have no choice. We cannot pick up and move our business. It will take way too long. It will cost us a lot of money, and now the leverage pendulum is in the favor of the landlord. The earlier we begin, the better position we are. So all of you, I'd like for you all to take a look at when your lease is set to expire. Not just the option dates, but the actual initial term of the lease. When is that set to expire, and how much time do we have before that expiration date? So all of you, I'd like you to note down, please, 24 months before expiration is when you should get in touch with a group like ours to begin understanding the nuances of your lease agreement and effectively beginning to devise a lease negotiation strategy. I'm going to quickly go over the right treatment plan in terms of our process as a firm. When we get involved in a lease negotiation, typically we like to get involved 18 to 24 months before expiration. We do have a well-structured process that we have been working with the last 25 years to have a successful outcome when it comes to negotiating the terms and conditions, rent rates, and additionals for the lease agreement. We begin by gathering all documentation, ensuring that we have all correspondence with the landlord, all original lease documents, any proposed assignments, estoppel certificates, non-disturbance agreements, any document pertaining to the real estate component. It's critical that we have all eyes and ears taking a look at that because it does have an impact on our strategy and our negotiation stance. Once we have all documents, we look to identify your practice and career goals. How long we plan on practicing, what the transition plan looks like, are we ever planning to expand, open up multiple practices, or even relocate the business. Critical that we understand that as we're devising strategy. Then we look to review the office lease agreement, identify all the risk provisions, any issues that may come up as a contentious issue when we get involved in the negotiation, or any items that may pose a risk for you today as well as tomorrow, and more importantly when you're looking to sell the business. At that point, we would have our market research team prepare all the research for the area, comparable rental rates, average rental rates, availabilities, key performance indicators, growth rates, vacancy rates on the property, as well as the area, so that we get a snapshot of the local marketplace. So when we get involved in the financial negotiations, we can have an intelligent discussion with the landlord based on scientific data of average rental rates and what's going on in the market. And that way, we have an understanding of where rent should be and can have an intelligent discussion based upon that. Once we have defined our market research, we would develop an outcome and strategy plan. What the strategy is going forward, customize strategy for your lease negotiation to ensure that all items will be addressed and that there is a plan in motion to ensure that you get the best result when it comes to negotiating your new office lease agreement. Once we have determined the strategy, we would then get in touch with the landlord to hammer out the negotiations of the economics, what the base rental rates are, what any tenant improvements allowed, so any allowances for the landlord to contribute to the build-out, what the CAM cost estimates will be. CAM being a very important, that's common area maintenance. It is a variable expense that fluctuates based on the business operations of the property. So we do want to ensure that we don't get hit by a very expensive bill for something that we weren't aware of, such as a redevelopment of the roof or a redevelopment of the parking garage or parking lot, which can cost us a lot of money in 1 month if we are expected to pay that as a tenant. Once we have identified the economics and have agreed on the economics with the landlord, then at that point we would get to that 70 or 80-page document, being your office lease agreement, those painful to read lease provisions that are often very confusing. We go through each item detail by detail, line by line, to understand what obligations, commitments, and legal binding documents you're committing yourself to for the next 10 to 20 years. We would get into negotiation on understanding and clarifying those legal documents and creating a dental-specific lease agreement. Once we have negotiated the economics and the legal terms of the lease agreement, we would then ensure that the final lease agreement is reviewed and to ensure that it is consistent with the negotiated terms in previous discussions with the landlord. Many times when we have gone through a very painful or even a long negotiation, and we often see landlords do a bait and switch where they effectively change the lease agreement at the very last minute that opposes what the negotiation terms were. So we do ensure that the final form of the lease agreement is consistent with the previously discussed items that were agreed upon. So this is our tenant lease cycle. Again, critical we begin the process early on and that we have all documents and understanding of the local marketplace before we even pick up the phone and call the landlord. A strategy is devised and we begin that strategy as we enter into the negotiations. So some key takeaways as I wrap up today's webinar. My component of the webinar on the lease agreement. Ensure that the details of your lease agreement are set up to support your smooth and profitable practice exit, that we're preparing for our lease and eventual sale of the business, and that the real estate strategy is in line with our transition plan. Be strategic. Critical that we understand to ask for the right things. You do not get what you deserve, you get what you negotiate into your lease. And one of the benefits that we do and have at Cirrus is, based on our experience, we know how to ask the right questions and we know how to request the appropriate items and merits of the lease agreement to effectively address them. Critical that you have your office lease agreement reviewed by your professional leasing experts to ensure that your lease is set up for a smooth and profitable transition and your wealth and significant asset is protected. Again, start the negotiation process early. If you're planning to retire in the next 10 years, now is the time to start planning. Begin and understanding that your real estate strategy should correlate with your eventual transition plan and your exit plan. So quickly, we do offer a service that I'd like to offer everyone today. It's called a critical dates and risk analysis. It's typically $1,500 where we spend 3 to 4 hours analyzing your lease agreement, identifying any of the traps, provisions, and details in your lease, developing a vision and plan going forward for the eventual sale and long-term plan of the business, uncovering the traps, determining what an ideal lease should look like, as well as giving you a tactical plan on how to negotiate a better lease agreement. For the next 2 weeks, for those of you that get in touch with me, and I will provide my information at the end of the webinar, our core sponsor will be waiving that fee. So it will be effectively a no-cost lease review, which is typically $1,500. And I do like to know, please email me or give me a call if you would like to set up the lease review, as you will be offered that service at no cost for having attended today's webinar. Again, there is a 2-week limit on that service. So for those of you interested in having a complimentary lease review, I'd be more than happy to do so at no cost, and we can take a look at that and determine the risk assessment of your practice lease, as well as understand what the rent analysis is for the practice real estate to determine what fair market value is and ensure that your economics are properly addressed with the negotiations. So my name is Jazz Banga. Thank you all for your time. I'm going to segue over to Adrienne Twigg at Bent Ericksen to go over some HR solutions. So for those of you that were in attendance for the leasing component, thank you for joining me. My contact information can be found here and at the end of the webinar. Please do get in touch with me to schedule your complimentary lease review. Adrienne, I'll let you take it from here.
Great. Thanks, Jazz. And thank you to Cirrus for allowing us this opportunity to share our services and to talk about some of the risks that are involved in the human resources part of your business. My name is Adrienne Twigg, and I am with Bent Ericksen and Associates. And at Bent Ericksen and Associates, we deal primarily with dentists and in the dental profession, all types of practices in all 50 states. So we have clients all over the country that we work with on their HR piece of the business to keep them in compliance and make sure that they're doing what they need to do to avoid any type of legal action in the labor law industry. So if we start out talking about what employment compliance is, even though we like to call this section "What You Don't Know Can Hurt You," we really could just as easily call it risk management and asset protection. So just like Jazz was talking about looking at your lease and being proactive and making sure that you know what's going on with your lease, it's the same thing for your HR section of your practice. So we have a scenario here that, let's say, as a business owner and as a dental practice, you have a policy in your employment handbook, in your policy manual, that tells your employees that they cannot talk about their wages or their benefits or anything else, because if they do, then that could be grounds for their termination. Well, then you find out that you have an employee who actually does complain about her benefits or her compensation, and not only does she talk about it to her employees, but then she also gets on Facebook and starts talking about that. Well, you have in your policy manual that if anyone talks about that, then you have the right to terminate them. Well, if and when that happens, you say, okay, you terminate her for violating that policy. So if you do that, what type of liability and risk do you have for taking this action? Well, today you would have a major liability there. The National Labor Relations Act was put into effect a number of years ago, and it put into effect a law called a Protected Concerted Activity Law. And what this does is it protects the employee to be able to talk about their wages and their benefits and maybe the compensation and what's going on in the practice. So this is kind of a setback for employers if you don't know about it. And if you have a policy in your manual that states that they cannot talk about wages, you need to get it out, because as of right now, it is illegal for you to have that. So a myth or reality, as an employer with only a small number of employees, you don't have to worry about compliance with the labor laws. True or false? Well, today the reality is all employers, regardless of your size, must comply with about 95% of all the laws that are out there. Some of the trending statistics that we are seeing in the labor field out there is that settlements now, out-of-court settlements for labor law disputes, are running about $25,000 on average. And that is just the settlement. That's not legal fees or anything else. We're also seeing that labor-related lawsuits are more prevalent now than malpractice. So that's something you need to watch. There is a insurance policy out there that you can get as an employer, and it's called EPLI, and it's Employment Practice Liability Insurance. Right now we're seeing that the premiums for this type of coverage is actually higher than malpractice, so that lets you know that it's being used quite a bit. There are federal laws, state laws, and sometimes county and city laws that come into effect that you need to be aware of and make sure that you're complying with. As the employee thresholds which means the number of employees that you have employed in your practice go down, then the applicability and the risk and the liability to you is going up. So that means you really have to be aware of all of these thresholds. So as you grow, naturally you're going to be adding staff, and your HR risk is going to go up. We've identified some compliance challenges that you have in the dental industry. One of them is record keeping. When you're in school, you are pounded with making sure that you chart everything, making sure that you have your notes correct. So record keeping is a big compliance issue for you. And then you have OSHA and HIPAA. And as we all know, it seems like there are statements and letters and updates and alerts coming across your desk almost on a weekly basis about things changing. I managed a very large dental practice in the Midwest for almost 18 years, and we had 3 doctors, a staff of 30, and it seemed like every week when I went through my mail on a day-to-day basis, there was an alert coming up that something had changed with OSHA or HIPAA. That's just kind of the nature of the beast. The fourth challenge that we have identified is employment. Employment law and employment practices are huge in running your business. You have all of your protocols and your procedures. You have policies with all of these challenges, how to do something, what to do when something happens. You have all types of manuals and forms, and then you have to stay up to date with everything. So hopefully you have a system of phone support that you know who you can call if you have questions. All of these protocols and things are put into place to reduce your risk, to protect you from any type of dispute or labor law issue, so that you can really focus on what you went to school to do, and that is provide dentistry for your patients. So let's take a look at the first, at one of the first compliance issues. All it takes is one employee. So for us, that really does have 2 meanings. All it takes is one employee, and you are on the hook to go by 95% of all the laws out there. On the other side of the coin for this, all it takes is one employee, and you could find yourself in front of a labor law board or worse in a civil lawsuit for something. The second compliance issue is you have not one set of rules to abide by, but you have 2. You have the federal rules and the state rules and laws. And a lot of times those do not coincide. They are not the same. So you need to be aware of what law takes precedence. Now, when we talk about federal and state law, if those 2 differ, then you are required to go with the most stringent law. And then you may ask me, okay, Adrienne, I'm not sure what the law is, but when I find out and they're different, how do I know which one to go with? Which one is the most stringent? That part is very easy. The most stringent law is the one that favors the employee. So I know sometimes doctors look at me and say, well, you've got to be kidding after all I do for my employees. But that is the way the law is structured. You have to go with the law that favors the employee the most. So another issue with that is it's always changing. It seems like they are constantly changing the law, such as January 1st, something comes into effect, or July 1st, something. So you have to be aware of what's going on and how these issues are changing. So did you know that following pregnancy leave, you must now extend breastfeeding rights? Which is it? If you have 15 or more employees, unless your state has a lower number, or is it only if the employee works full-time? Is it always, regardless of the number of employees that you have? Or is it just for 3 paid breaks a day? Well, I'm going to let you off the hook with this one and give you the answer really quickly. It's regardless of the number of employees that you have. With the Affordable Care Act that was put into place a number of years ago, now as an employer, regardless of your size, you must provide accommodation for working mothers in the workplace. You have to provide a time for them to either express milk or to breastfeed, and it has to be a private space, and it has to be something other than a bathroom. It has to be somewhere that they are assured they're going to have privacy and not be interrupted, and you have to provide this for them for up to 1 year as a minimum. So with all of these things going on, what are dentists out there doing? What are they doing to try and get in line with all of these compliance issues? Well, some of them are trying to do it themselves. The issue with that is you really don't know what you need because you don't know what you don't know. And then trying to keep everything current and up to date, you have to ask yourself, is this really the best use of your time? Well, then you could hire a staff member, but if you're going to hire a staff member to take care of your HR needs, they need to have some type of credentials and certifications. Then you're going to be looking at a pretty good size salary, and you have to wonder, okay, is this the best use of your money? Well, then there's the issue of hiring an attorney. You can do that, but we recommend if you go down the route to hire an attorney, that you hire a labor law attorney, not your cousin Vinny that handles divorces, or maybe someone that you know that handles real estate, but someone who specializes in labor law and knows dentistry. We have found an average cost for a policy manual from an attorney is about $5,000. You're not going to have job descriptions with that. You're not going to get personnel forms. And then that's only going to be good for maybe a year. But like in all other professional businesses, when you call to get asked questions or to get updates, you're going to be on a meter, and you're going to be charged for those updates and any advice that you get. So then you have to really wonder, okay, is this cost effective or is this smart? So the example that we give is, how about partnering and co-sourcing it out to an HR firm? For the record, Bent Ericksen Associates is an HR firm, and we do this on a daily basis. This is what we eat, sleep, breathe, and think about. So if you go with an HR firm, you are basically getting an outsourced employee without the cost of having someone in the office to do it. It really is the most easiest and cost-effective way to take care of your HR concerns and then allow you to focus on the dentistry that you went to school to do. So let's take an example. A dentist fired a staff member and was sued for wrongful discharge, emotional distress, sexual harassment, discrimination. All this came to the tune of $200,000. This is a pretty big sum and a pretty big threat to be looking at. So you could say, well, you know, that's not ever going to happen to me because I live in an at-will state, right? So if you're thinking that, then you may be thinking at will. That means that I can terminate an employee anytime, with or without reason, with or without cause, and not have any problems, right? Well, let's look at one more scenario. You have a dental hygienist. Let's say she's 46. Her performance has kind of been slipping, and you've added new technology to the practice, and you really don't see her embracing that. So you think, I am an at-will employer. I can terminate this person. So you terminate her. She turns around and files an unfair termination claim saying that you fired her because of her age. Well, just so you know, the breaking point now for age discrimination is 40 years of age. So 40 years and older could fall into an age discrimination class. Well, you contended that you did not fire her because of her age. Her age had nothing to do with it. You fired her because of her poor job performance. The catch with this is you don't have any documentation supporting that. You don't have any performance evaluations or any memos or notes that you've talked to her about her performance, but you just say she was an at-will employee, so you could let her go. Well, what's your risk? Well, as I was just discussing, anti-discrimination laws were put into effect in 1962. They're all listed under Title VII. The basic tenets of Title VII is you cannot fire someone because of their sex, race, color, national origin, or religion. Now, while this in no way touches all of the different levels and tiers of discrimination out there, it's a pretty good building block. They came along later and put in a Pregnancy Discrimination Act. You can't fire someone because they're pregnant. You cannot fire someone because of a disability. You cannot fire someone because they're wanting equal pay, or older workers benefit was put into place. The Age Discrimination Employment Act was put in. You can't fire someone because they're associating with someone maybe that you don't like, or definitely if it's a whistleblowing scenario. I was in a meeting last week, and the gentleman that literally wrote the book on OSHA said that as of today, right now, 100% of the complaints that come into OSHA about a practice not being in compliance is from a disgruntled employee. So whistleblowing and the whole thing of retaliation, if you were to fire someone in retaliation for something like that, is totally against the law and puts you at risk. And of course you have all of the harassment, sexual harassment, hostile workplace, work environment issues that can come into play as well. So all of these that I've just named are considered protected classes. And if you look back through them, you'll find that there aren't very many employees that you have in your practice that would not fall in at least one of these categories. So it's really important that you know what the protected classes are. The evolving trends that we're seeing out there are ban-the-box legislation. They're looking at legislation so that you cannot ask a prospective employee now if they have any type of criminal history or criminal conviction. You can't ask about salary history. As you know, that's in the news a lot now, that they're trying to do away with that. The minimum wage increases are there. So as you can see, there's a lot of trends that are coming on that as an employer you need to be aware of. So really, all this amounts to the game has changed, folks. The workplace really has become a legal minefield. And if you are not prepared as an employer, this can really cause you problems. So if we go back to that $200,000 lawsuit, not having your ducks in a row and knowing what is in front of you really can cause extreme distress and find yourself in one of those situations. Our contention is for this not to happen to you, that you have to act. So our acronym for this is you have to have some awareness of what's going on and what your responsibility as a business owner is. Once you know that, then you have to have a commitment, and that commitment is going to be so that you can take some action. So some of the benefits of taking action and making sure that your practice is in compliance is you'll find you have fewer staff misunderstandings. If you have a policy manual that's current, up to date, and has all of your policies in there, you're not shooting from the hip. When someone comes to you and asks you a question, you know exactly what the answer is because you have an up-to-date policy manual that talks about that. If your employees know what's expected of them, you're going to find that you have reduced turnover. When you have reduced turnover, you're going to have improved morale because you're not constantly changing the chemistry in the practice. You have a set team that gels and works together, providing better job performance. When you've got a team functioning well, everybody's just performing at a higher level. It's going to lower your employee-related stress. When we give these seminars across the country, and I ask, how many of you doctors deal with employee-related stress? And I ask them to raise their hand. Some doctors will raise 2 hands because employee-related stress is something, reality that they're dealing with. When you have your policy manual into place and everything is running, you're going to have greater hiring success. You know what you're looking for in an employee, and you can explain what your benefits are and what you have to offer as an employer. It's also going to give you some prevention from litigation, finding yourself in front of that labor board or worse, in front of a court for some type of allegation and violation. So the peace of mind that you get because you know you have everything in a row and you've taken action to make sure that your policy manual in your office is compliant. So we have really identified 5 fundamental pillars of HR. Number 1, most important, is having a personalized policy manual. Having a policy manual that addresses your practice specifically, the state that you're in, according to the number of employees that you have, is a key function. The next pillar that we will look at is, why you have policy manuals is to establish the rules and the expectations that you have, making sure that you have everything combined there, that you can treat your people consistently and that it's going to comply with all of the laws. It really will simplify your life. You have to learn a 1 sentence, 5 words. Go look in the manual. That is going to give you all of the answers that you need to answer any question about anything that your employees bring to you. Also, having individual job descriptions, making sure that they're updated, that they're ADA compliant, and for this we mean Americans with Disabilities Act, not the American Dental Society, but having job descriptions that are individualized for each position in the practice. Like I said, making sure that it's ADA compliant. If you ever have to legally defend yourself as to why you hired a person above another person or why maybe someone didn't work out, maybe they didn't follow the job description, they weren't able to perform the tasks. It also comes as a recruiting tool. It helps you write the job description that you're looking for. If you're looking to hire, it's going to identify the tasks that are required in the position, making sure that that employee comprehends what they are required to do. And it really does become a recipe for that job. It lets the person know what's expected of them, and it outlines all of those expectations in the job description. It's going to identify any training needs, any special capabilities and skills that are needed. It gives you a real basis for goal setting for that employee and for doing performance reviews. You use the job description as your benchmark, and it's going to support the staff's accountability on performing that job. The next pillar is good documentation, and not just documentation, but good documentation. So, did you know that if a claim of discrimination comes down to a he said, she said scenario, that if you don't have your documentation in place, then you are going to lose 85% of the time. So in this case, you're guilty until you prove yourself innocent, and you prove yourself innocent by good documentation. So when we talk about the good part of that, good documentation needs to outline the performance deficiencies. You need to set what you expect the improvement to be, and warning of the consequences. What happens if you don't see the improvement? Have the employee sign off on it, saying that, yes, they had the meeting. What the employee needs to understand is this doesn't mean that they necessarily agree with everything you told them, but it does mean that you have had the meeting with them and you've told them of the job deficiency and what you expect to see as an improvement. So basically, you are just demonstrating a pattern of behavior, and if it doesn't work, then they're showing a failure to improve on the job, which is key. We recommend that you have 3 sets of personnel records, that you have separate files. You have a regular file where all of their licensures and their application, their any performance evaluations that you've given go into that. A confidential file you'll keep if you have done any type of background checks. That type of documentation would go into that. And then you also have an I-9 file that all of your I-9s on all of your employees go into. So they should all be organized for you and easy for you to maintain and keep up to speed and keep up to date. And then the fourth pillar is compliance alerts and updates, making sure that you are staying current on all of the regulations and rules, laws that are out there. As an employer, you know what's going on and that you have someone to call, making sure that you're compliant. The fifth pillar is really your HR component, making sure that you know who you can call if you have a question about an employee issue. If you've got someone you're dealing with, maybe they have a tardiness issue, how do you deal with that? If maybe someone needs to go out on a pregnancy leave, what are you required to do? As a small business owner, are you required to hold that position? And if so, how long? These are the types of questions that sometimes can be vexing to an employer if you don't know the answer.
For those of you that are interested in setting up a consultation with either Cirrus or Bent Ericksen, our respective numbers and names are here, and we'd be more than happy to set up a brief consultation. I would recommend getting in touch with Adrienne or myself to coordinate the HR or lease consultation. Both of our information will be found here. The polling information will follow in about 2 minutes. That way you can take a poll of this afternoon's webinar. And I would like to thank everyone for attending today's webinar. I hope it was very resourceful and you guys all learned a bit on the HR side as well as the leasing side on really how to protect yourself and minimizing some of the risks and exposures that are persistent when operating a dental business. So I'm going to move forward to the polling section. Again, here are our respective emails and contact information. Feel free to email Adrienne or myself, Jazz, and we'd be more than happy to set up a consultation. Thank you all again for attending today's webinar. It's greatly appreciated.